Уважаемые дамы и господа, уважаемые участники форума, я прошу всех наших иностранных участников.
Ladies and gentlemen, I would like to ask our foreign delegates to take the headphones. It's a big pleasure and a great honor that awaits us is a lecture by the most famous professor, Valery Dmitrievich Zorkin, who has been supporting our forum for 4 years in a row. We are very happy that we have such a big event and that we have such a pleasure to hear Valery Zorkin speak. I don't want to take too much time from your presentation, from your lecture. I like to congratulate you on such a wonderful opportunity. Good afternoon, ladies and gentlemen. It's a great honor to be able to speak at such a high-level event, the International Legal Forum. I thought that perhaps I would not have it in myself to step out here, but then I decided that I have already jumped into the water. And as a professor, as an old person who hopefully did not get into senility, I thought that the lecture consisted of 2 academic hours. And in fact, I prepared 3 texts for this lecture. And then I published 1 text. It's on the law and economy. Then there's the second speech that I prepared on the crisis of international law. And the third speech that I prepared is probably the less exciting speech about the rule of law. In the program, the title is The Law and Civilization, and I would like to ask the interpreters to take the... Dear colleagues, ladies and gentlemen, in the Millennium Declaration that was adopted by the UN General Assembly in September 2000, the governments have stated that it is important to increase the respect to the rule of law in international and internal affairs. The implementation of the rule of law is an important basis for the implementation of a legal system of every state and ensures the best implementation of human potential. Why did I decide to entitle my presentation Civilization and Law? I looked back at what people write about the modern man, because there are a lot of definitions of what a man, a human being is. Some say that the human being is being with an earlobe, and there are no other species on this earth that has an earlobe. But of course, when we talk about law, the earlobe is not the most important part. But we're going to talk about something that the modern man cannot exist without. When we talk about the doctrine of the rule of law, I think that the famous principle applies. There's nothing more practical than a good theory, because law, as the form of all that is sensible in human society, as Valentina Labaeva wrote in her publication, it is a form of freedom that the human being exercises in his social interactions. It is not just a human being that is a social person that has a free will, but it's also a system of regulation of a normal everyday life of all people, and I cannot but agree with that. I have to say that this idea of what the rule of law is has a practical application. And I'd like to tell you, my dear colleagues, that we have already developed and introduced into practice The Justice Project that developed a number of criteria and a number of principles that can be applied in many different countries of the world. These indicators, these principles have been developed by experts, and these principles make it possible to assess the degree of limitations of freedom, the guarantees for the protection of major freedoms, the transparency of government institutes, and the quality of justice. In any case, in my view, we cannot still say that we have an adopted and agreed upon doctrine of the rule of law, even among the countries that belong to the so-called developed democracies. We do not agree on the interpretation of this notion. And the reason is not only because there are certain traditions coming from the Anglo-Saxon law and from the continental law, and that they contradict each other. There are, in fact, a lot of other factors. Nevertheless, I can see that there is a certain process towards becoming closer on the interpretation of this notion. We are talking about the social norms of human beings. And in order to understand where we are, we need to understand what rule of law is all about. The speaker is not using the mic. Sometimes they say that rule of law is a protection against abuse, against the abuse from the government or those in power. And then there's also a link to the famous saying by Montesquieu that there's nothing worse than the tyranny which is covered by law and the front of justice. But if you look at law as an element of a social system, then you have to agree that the rule of law also means that it should be supreme over other subsystems of regulation. And I believe that such priorities would be best for the society and are absolutely necessary for the government. Only then we can talk about these norms, and that the state should not have a state religion, state morality, state ideology in this interpretation. Otherwise, there will always be something that stands at the very top, and if it's not the law, then what can occupy that position? And then we can encounter serious problems, not only of practical nature that are related to the implementation of the rule of law principle, but also some problems of theoretical nature, the problems that reveal the unclarity of some of the principal notions. In order to illustrate this problem, I think it would make sense again to quote Montesquieu, who believed that people take offense when others trespass on their traditions. And the trespass on the traditions always serves as an indication of contempt. I do not want to urge you to preserve old traditions and stereotypes, which are a specific format of the way to exercise pressure on the personality. But I believe that some element of healthy conservatism, a liberal conservatism in the sense of liberal freedoms, has to be preserved when we try to understand the internal link between law, morality, and religious values. And the gap, the breakdown of this internal link may be too hard on societies with traditional ethnic, family-oriented and confessional morality. We're talking mostly about requirements to tolerance and the so-called sexual values, about specific cases of the juvenile courts that create danger of taking children out of normal families. We're talking about the commercialization of those areas that have specific social significance. For us lawyers, it is important that the notion of social norms is related to our topic. When we analyze this problem, we have to realize that the social norm is something that works towards the preservation and development, but not the destruction of the social community or the human community. It has to be neutral to certain departures of social norms if it aims to preserve the social unity. But it should not act to support propaganda or other forms of departures. It is one thing when you make it possible to adopt children by families where two parents are of the same sex, and we shouldn't talk about this. It's not appropriate. I think that it is very clear that even in Europe, which some people call post-Christian Europe, there's a very the many different approaches and many views on the practice of adopting children by families with parents of the same sex. On the other hand, we should not confuse healthy conservatism with bias and pressure on the dignity of a man. And from this point of view, the rule of law in the social norms, in the system of social norms, should not allow for the pressure on the dignity of man. And from that point of view, the rule of law should support the dignity and it should not infringe on the dignity using the cover of the protection of moral or religious norms in order to guarantee lack of discrimination regardless of the sexual orientation and gender, or regardless of the lack of clear gender. And that was what was reminded to us by the winner of the recent Eurovision contest, and you can see the Wikipedia article on that. In view of that, I would like to underline the very important idea here, that when we talk about the rule of law in the modern context, we have to understand that we are mostly talking about the supremacy of human rights. This approach means that the rule of law is a system of norm of institutional protection from arbitrarily abuse, includes the protection for the dignity. And some authors even say that in this interpretation, the rule of law means the protection for the dignity, and it is taken out of the formula for the protection from arbitrary abuse. This also means that the rule of law includes the protection from arbitrariness, and it guarantees the support to dignity. In any case, the central link of the modern doctrine of the rule of law, in its difference with the doctrine of the rule of legislation, includes the human dignity. The supremacy of legislation should be included in the doctrine of the rule of law. And it's sometimes strange to read publications in Russia whereby people write that the rule of law comes from very old traditions of Russia. And of course, the person who writes this article knows German and knows that the German notion of Gesetzlichkeit is one of the the principal norms of the German constitutional law, which goes back to the 19th century lawyers. It was developed further in the 20th century and is currently used.
And now a couple of comments. For the sake of interpreters, I'd like to now skip a very big portion of the text And I encourage you, the interpreters, to do the same. Significant part of the difficulties related to how to understand and implement the principle of rule of law, whose epicenter is the human right and human dignity, has an in-depth nature due to historical and geopolitical factors. And that creates a situation where some politicians and experts start speaking about basic archetypes of society which block the gradual legal development of a country. Some even speak about a problem of social and cultural clash, which has been pretty traditional for Russia, which has been going through the genotype of the Russian people, and which was exacerbated by post-socialist reform of social and political relations. I disagree with those who interpret a very complicated social and cultural situation in Russia as a vicious circle, magical vicious circle, which prevents Russia from getting out of a dead end, the dead end described by such scholars. I think that the nation should take all necessary steps and measures and prevent a situation where inter-party fight for power could result in Russian societal gap or clash. And that is what internet pages like to write about when they speak about column number 5 in ward number 6. What has to be done to make movement towards rule of law stable and irreversible? I'm quite convinced that the principles and difficulties related to the implementation of rule of law principle in modern Russia should be found not in the constitution. Those should be found in the practical implementation of our constitution, of its text, if you will, and the whole legal system, meaning that the constitution as a document is a way to formalize a public agreement about the principles of government and societal setup. Its foundation, however, should be a real agreement among basic social layers and groups in society where we live. The agreement should be on the goals of post-socialist development and how those goals can be achieved. Because rule of law is a kind of quintessence of this agreement based on a combination of social interests. The development of social accord as foundation, the only foundation for rule of law, requires mutual efforts from the government and the general public. Because I cannot discuss every aspect of this multi-faceted subject, I would like to focus on what needs to be done to achieve rule of law, those which are pertaining to the judicial branch. The quality of judiciary, if it's not the most important condition, it's a critical condition enabling Russian society and government develop. It lies and it predetermines not only political but social and economic development, because independent judiciary is a factor which predetermines the people's attitude to the government policy. It predetermines people's trust in Russian government here, domestically, within the country, and internationally. And that predetermines a successful development of Russian business, Russian economic attractiveness in terms of foreign investment, etc. It is not for nothing that recently Russian scholars, not just lawyers, but economists and other scholars, have been attaching more and more importance to non-economic factors of economics. The central place there is taken by the legal system of the country and the system of justice, while some leading experts in the area of emerging markets and major investors all agree that a transparent legal system and judicial system is not quite necessary. It's more than necessary. It's a critical precondition precondition for Russian economic development. There's two extreme opinions, two extreme approaches in terms of judicial system. Both are dangerous for social mentality and social and Russian legal practice. You know, I'm a frequent internet user, not because I'm a 17-year-old teenager. I don't go back, no, believe me, even though that age is pretty attractive. But no, but it's just that I wouldn't like to drag behind the rest of us. I've been on this website where I read. So this teenager asks a teacher a question. He says, "Dear teacher, could you give me a bad word, curse word, consisting of 3 letters where the second letter is U?" And of course, this boy was talking about court. In the Russian translation of court, the second letter is U. And the other extreme is, look, everything is over, the reform has been completed, life is smooth and beautiful. Occasionally, somebody does something bad, but that is very infrequent. That's the other extreme. Of course, we should exercise critical thinking and realize that social science ratings are quite relative. I'm not saying that they may be used as statistics in terms of, there's a lie, big lie in statistics. I'm not referring to surveys as sources of big lie. It's just that you have to exercise adjustments when you deal with statistics or the results of the surveys. But for Russia, I believe the statistics don't look as bad as they could. I'm not referring to private surveys or fragmented surveys. I'm making reference to well-known survey centers. So since 2004, between 2004 and today, if you look at the statistics within that period of time, it looks like positive attitude to court has not become any better. The number of negative attitudes went down from 46 to 35%. Many people, even if they say that you only go to court after you have exhausted everything else, but 1/3 of Russian citizens has been to courts over that period of time. If you remember that this country, in addition to criminal civil cases and other cases, you have between 21 and 24 million different cases. Even with negative attitudes and negative feedback, the statistics are big enough to make you think. And at the same time, we realize that some in-depth changes are required, not one-time changes. And at the forum yesterday, at the previous forum, there were a lot of comments showing that Russian businessmen prefer London courts to Russian courts. It's a fact of life. But how can you interpret this fact? Some say we should prevent them from going there. Some others say, no, we should create Russian judicial system which is attractive. And there is another option which is very often ignored. Well, they go to London courts, while ordinary people cannot afford that. They just cannot. So we don't want a situation where you have some very limited privileged groups, houses, schools, and where there are people who are privileged enough to use the best judicial system, something that ordinary people cannot afford. So once again, there's a lot of fruit of thought. For the sake of interpreters, I'm skipping everything that is crossed out on yellow pages. And now, after those sheets of paper fell down on the floor, I wouldn't like to remind you of Brezhnev. You remember that famous joke when he went back to the previous page and started reading on the rule of law, addressing Margaret Thatcher while he was talking to Indira Gandhi. And then he said, yes, dear Miss Thatcher. And the interpreter goes back to Brezhnev and says, no, it's not Margaret Thatcher. And he says, what are you talking about? I have Margaret Thatcher in front of me, and it was his assistant's fault who gave him 4 copies of the same text. I have only 1 copy. I'm fine, I'm good. Let me go back now and speak about how it is necessary and expedient to make sure that we have closer cooperation between academic community and the judiciary, so that it could be possible to develop a better justice doctrine, so that it could be possible to summarize the judicial practice in a way which is better than has been done before. You know that interpretation of law and application of law may be an aspect which may help Russia overcome some of the negative features of lawmaking work when you amend laws too frequently. You can understand it. Life doesn't stand by. You have to catch up, but you don't get over this proportion. We have had a lot of positive developments here. I would not like to describe it in every detail. There is something else I'd like to focus on now. That's the idea of rule of law. Because we live in an international law context as a country. There are some aspects here I would like to highlight in a really fast way, in a really brief way. As for the International Legal Forum, the implementation of rule of law ideas are especially interesting in the space of international law. In the Council of Europe space, which is most critical for Russia, I don't want, or I'm not willing to comment on the Parliamentary Assembly's decision taking the voting right away from Russia till the end of this year. I do hope that those difficulties are temporary. We don't want to overestimate them, neither do we want to underestimate them. I'd like to make reference to our founding father's comments, head of the International Affairs Committee, Alexei Pushkov, who said that most people in the Parliamentary Assembly betrayed the principles of rule of law, supremacy of human rights, and supremacy of legislation. Most of them went for servicing political interests of a group of nations which look to use Ukraine as a country within their geopolitical interests. But there are cultural and economic features of the countries which, like Russia, became members of the Council of Europe after the disintegration of the socialist system. Of course, I'm speaking about the problems caused by objective transition period difficulties, like disbalances in the separation of powers, underdeveloped parliamentarianism, and a situation where national legislation does not comply with international law 100%, including the area of human rights. But those problems should not be misleading. The farther we are from the disintegration of the Soviet Union, the more important are the factors of geopolitical and social and cultural nature, because they predetermine civilizational differences between and among post-socialist countries. Without going deep into geopolitical analysis,
such factors as the geographical location of the country, the space, the area, the natural resources, the structure of productive forces, the social structure of the society, the quality of life, the demographic situation in the country. I would just like to say that the combination of all these factors predefines the serious differences in the nature of the constitutional acts approved in this or that country. And it's also important important to remember what particular conditions existed at the time when the constitution was adopted, whether it was a situation of a very sharp social break within the country, whether the country was a uniform country, a unified country. As in Russia, for example, the adoption of the constitution occurred at the time of the political crisis, very similar to the small civil war, really threatening the whole statelessness state of Russia. And over the first 10 years of the constitution, this social political conflict was of the major importance, and it was the major threat. In my opinion, there are other very important threats and challenges: poverty, corruption, social inequality, the downgrading of the technological infrastructure. All these can be overcome. This can be overcome with the help of certain programs, but the disintegration of the state, as the practice demonstrates, is irreversible. At the same time, the liberal principle, not the man for the state, but the state for men, means that the state should be retained as an institute capable to defend the rights of the citizens. In this sense, when we talk about the priority of the rights, human rights, and we're saying that the human rights are of primary importance, then the second article of our constitution should be quoted. It's the main value for the country. It doesn't mean that religion is not the main value for some people at all, but I really would be against the overestimation of the article, but at the same time, we should not underestimate it. From this point of view, it is extremely important to find the proper measure in the protection of the political rights of our citizens, because on the one hand, lagging behind of life and running ahead of it is very difficult for the introduction of the ideal parameters. Attempts to introduce these ideal parameters very well working in other countries in this or that country can be less successful and even catastrophic. I can relate to economic reforms here. The shock therapy, economic therapy, in certain cases is useful, but in certain countries it brought about tragedies. And this is something that the politicians soon should think about, but the legislators as well. As for these particular specifics, allow me to give you an example. Resolution of the Constitutional Court concerning the religious parties. In Germany, as we know very well, and in the names of the parties, the religion is present. And this is typical of other countries as well. I'm not going to say whether they are truly religious in Germany or not. But in Russia, in any case, particularly at the time when the decision was being made, it was quite obvious that even the name could easily provoke national, ethnic and religious hostility, because religious parties in this case would have been formed on the basis of ethnic principle and religious principle. And that is why I was looking with great concern at the situation when they were emerging these parties, and at the time when the Constitutional Court was in Moscow, in Lyinka, and there were many petitioners who were asking for a permission for the Russian Orthodox Party. And actually, this was the opinion expressed not by the regular believers, members of the congregation, but rather well-known people. So the Constitutional took a very proper decision. In the Russian Federation, considering its specific features, these parties should not be allowed, and this was probably against the legal positions developed lately by the Strasbourg Court for Human Rights and Freedoms. But actually it demonstrates that within this system of rights, as well as in other systems, we need to be within the social, historical and cultural context. Now, as for the social and economic rights, then of course the Constitutional Court has always proceeded from fact that in a social state, the rights of the citizens should be provided through compensation mechanisms open for the weaker members of the society. The equality of the startup conditions in the exercising of the rights and freedoms, and stagnation in the development of the society should not be allowed, because if this happens, actually, if there is stagnation, then we would not be able to find such talented young men as Lomonosov in the past at the Moscow University or other prestigious universities. I don't want to say that there are all sorts of byways, but I'm talking about the education and training. A family with good resources can provide their children with good opportunities for studies. I'm talking just about that and nothing else. There are problems common for new democracies in association with the protection of the dignity and honor of human beings. I already mentioned the family, marriage, and relationship between the genders. Allow me to remind you that well, in Amsterdam, everything is allowed. Not everything is allowed in Belgrade, and there are even more restrictions and bans in Makhachkala. Just imagine that everything follows the same set of rules and customs. In Belgrade, there is a demonstration for the equality of sexual minorities, brought about a very negative reaction of the mob, of the crowd, and this led to riots and to the beating of some of the participants. You can just imagine what's going to happen in Dagestan and Chechnya in the similar circumstances. So when people are forgetting about that, and I'm talking the activists of the movement and other people as well, well, I probably exaggerate. Then in this case, you shouldn't quote me, of course, in this case, but well, I'm talking in this case about these people who can be referred to as provocators, in fact. They provoke a certain type of reaction. We can just imagine what we might expect, what kind of a reaction we might expect. I have already mentioned the constitutional protection, but anyway, these circumstances should be considered. If the country in its system of legislation does not consider that, then it turns into a standard abstract state. And these standards might be the same everywhere, but in reality, all this is going to lead to something exactly the opposite. And I can recollect here a well-known political figure of Russia, who is not with us any longer, who used to say, "We tried our best, but you know the rest." Now, in the search for the optical forms and coordination within the framework of the legal field of Europe, we should rather talk not about standards, but about the development of the common norms on the basis of the wealth, cultural, philosophical, political, legal, developed by Europe. If we're talking about the European values, of course, and from this viewpoint, I would like to emphasize what I stand for. I believe that Russia is not beyond this field. Russia is within this field, not following the principle that we're poor, we're lagging behind, and we're waiting for those sitting on the other side to bless us. But we are in the same field, and we should be fighting, really fighting for these common norms. And look at the legacy of great Kant and of the time of Enlightenment. Let's look at the standards that are being introduced, whether they are pragmatic or not, and the legislation covering the prosecution, for example, is a good example of that. Now, do I have more time? No? The time? No? Is up? Well, to finish? So, Very briefly, I would like to refer to what has turned into a classical approach in the constitutional practice and even at the universities, the Markin case. Konstantin Markin is a former military who asked for a 3-year leave, just the way women ask for when they are on contract in the army. The constitutional said it's not constitutional. The Supreme Court says it is constitutional and actually dictated that our legislation must be amended in this particular context. The truth is somewhere in between, because judging by the last drafts of the Ministry of Defense, we can see that they suggest the following option. The option that we never ignored in our decision, because there's a discretion of the legislators. When the baby does not have any other parent, then this military officer can be accorded this particular parental leave. But if we follow the foreign countries, then we forget many of the other aspects that are related to this specificity of our own country. Now, there might be an opinion that everyone should have equal parental leaves, but on parental and equal conditions I'm not sure how it works in Western Europe if we take the vessels, for example. But we're not the burghers from Western Europe. We're not under the NATO umbrella, who are mostly working with the Americans. Or in close contact with them. We have our own reality, and we have our own army. It's not the army of Slovakia or of Poland, but it's the Russian army. So there are certain provisions that we cannot but take into consideration when we look at these specific examples and cases. But I would like to emphasize that this particular ruling and other rulings do not demonstrate that we are against the European Court. I'm not trying to justify our decision at all. Actually, I have always been on one and the same position. When I think about concessions, I'm not talking about the Strasbourg court in the negative sense. I don't intend to say that it should be done away with. But when the Constitutional Court and then Convention stand on similar positions protecting human rights, then interpretation by the Constitutional Court and the European Court might differ. And these differences can be based on very different grounds. Allow me to remind you the initial ruling of the European Court concerning the Lauzi case. You might remember a Protestant woman whose son went to a Catholic school in Italy with the crucifix displayed in the classrooms. You remember what the small jury said. It's not non-constitutional. Well, everyone who attended schools in Italy knows that these are not icons typical of Russia. These are typical of any school, of any university, of any castle in Italy. The crucifixion is always there, and Italy was very much against this particular situation, and 30 countries sided Italy in this case. And well, they turned into a third party in this particular case, and Russia supported this particular viewpoint, and the grand jury remedied the decision. And it's only through a dialogue, not through the confrontation, that these can be settled. Allow me to add that the Markin's case is just one case among many. When we had a different opinion as compared to that of the Strasbourg court. And in Europe, in Western Europe, not a single court has done as much as the Constitutional Court to promote the decisions of the Strasbourg court. I'm sharing this particular viewpoint, and we're acting within this particular framework. Now, since my time is limited and I still have about 25 minutes, allow me to conclude.
And then you may understand more about what I wanted to say. Why is it that the original title of my presentation was "The Civilization and Law"? I'd like to repeat, only because I had three parts of it, and two of them were already published, and the third one is I'm trying to present to you today. But there are other words that I would like to say. The rule of law as a universal principle of the international law and national legal systems of the modern era, and I would like to use the Max Weber's expression, the law that stands on the principle of a legal principle of being equal, of equality, and the famous legal researcher Rudolf von Ehring, in his publication Der Kampf um Recht, wrote, "While you fight, you earn your rights." The history of this fight has a number of dramatic and even tragic pages. We now witness the political madness and its extremes. As the French say, the style says a lot about the person. But if there is no style, which also happens, you will agree with me, then any style wins. If it may be a lower style, but it is the strongest that wins. If the political leaders have no style, and if a sergeant has the style, then it's the sergeant's style that wins. We have seen this in the past century, and we have already seen it in this century. I'm not going to name names, but I'm sure that you can guess who I mean. This is the way it happened in the past. This is the way it's going to happen forever. And as we read the analytics, if we look at how the countries go into the legal turbulence, I can't believe that I witness what was written in practice, because I definitely remember the time of the 1990s when there were a lot of heavyweights in the political arena. And I know that before the First World War, the dwellers of the political Olympus were also heavyweights. They were very wise. And yet the First World War took place. And it was the First World War that set the rules for the political life of the 20th century. The 20th century has gone through a number of dictatorships. It took the principle of ruling over everyone to the extreme. And I'm not going to put the communist idea equal to the Nazi idea. It does not equal national socialism. Yet the practice of the 20th century, the history of the 20th century, based its policy on something higher than just law. But then people realized that there's not a single principle that you can put above the law, because the law should be the highest principle. And I understand why people have realized that. Not only because the higher principles were compromised by practical implementation. It just turned out that any society cannot be governed by a higher principle, and it will not be able to live side by side with other nations this way. So if you can't do it in the entire world, you cannot do it in one country, even if you want to proceed from the pluralism principle. That's why I always believed that there should be a historic determination principle, a principle of historic approach. And we proceed here from an elementary basis that history has a different pace in different countries. If someone wants to implement these principles and others want to deny this principle, those that deny that principle may hide away. Others will try to pressure on this principle, and then the sores that form in this situation will destroy the society. It's impossible to put this principle as the main rule of life for one nation, for the entire world. That's why law stands above it all. So that starts with the modern interpretation of law in the end of the 20th century. So what has the humanity come to? Since if we're talking about the political front and the political leaders, fair elections, adopting a leader that has the votes of the majority, limiting the powers of this leader by law, living to the next elections. The humanity, which has got tired of 2 world wars and which fears the 3rd World War, that wants peace and prosperity, this humanity decided that stability can be achieved by implementing a simple agreement between the members of the society. Some people did not agree to that, but the majority decided that this is the best possible option. As one of the characters in the Dostoevsky novel said, it may be obsolete, but it is the best we have. This is the system that is based on a lot of errors that were made by the civilization. And this is the civilization of law, a legal civilization that emerged. I've always believed that I was part of this civilization, and I've always tried to serve my best to this civilization in the area that I chose while a student. This civilization is very fragile. It may be destroyed easily as we watch its destruction. For me, the collapse of such civilization would be as terrible as the collapse of the Roman Empire for its citizens. And I will be frank in saying that I hope that the law will win. And that's why I sided with my colleagues in the Constitutional Court in 1993. I can't say that I'm excited about the words of a famous philosopher, let truth prevail, but the world collapse. I think that if the truth collapses, then the world will be on the brink of extinction. Nothing can replace law. We cannot replace law even if we want to stop the world from collapsing. But I hope this idea can exist. Everybody does. But we don't have an idea that could work like that. And the legal systems deteriorate. And we have seen a number of cases where legal systems were replaced with violence. Tunisia, Libya, Yugoslavia, Syria. It was clear that one day this trend will be very damaging, will be fatal. Now in Ukraine, we can see that a sovereign state, which is in the middle of Europe, is interfered with. And there is a big campaign of falsifying real facts and events. There is biased interpretation of international and national law. It's a catastrophic event for the legal system. It takes the entire European legal systems to the brink of collapse. And it took long years, the entire 20th century, to build this system. I think the future generations will look with irony on those who try to destroy the very principles of their being. And I hope that everybody will be offended when some start applauding the collapse of these principles. But I am convinced that people who applaud this development, this event, will not last long. The civilizations, the structures that exist today are in a way the relics of the old times. And I hope that this picture of the future will stop these madmen. I hope that they will find some sense, and if they don't, then there should be resistance. And the resistance that possibly can be the foundation of the new legal civilization. Voltaire once said, the freedom consists in depending on legislation alone, on laws alone, and he meant laws adopted by the government. And Kant added that the only criterion for a free person in a situation where a man has only a starry sky above. There should be the second one, moral law inside. I'm totally convinced that this applies to the law in general and international law in particular. I believe that if not our generation, then the next generation will be able to create a true legal civilization, and the humanity will gain a better degree of freedom. I'd like to conclude with the citation from the Book of the Books. See, I haven't practiced delivering lectures for a long time. So it says, it was repeated by the fathers of the church. It was also repeated by a famous US writer who was translated back in the Soviet days, and you all remember it. But I will start from the original. Please, God, give me the power to do what I can. Don't let me do what I cannot accomplish. And give me wisdom to differentiate between one and the other.
Thank you very much. Because we live both in Europe and in Asia. When I say we, I mean Russia. Let me say goodbye to you like this as well.